What if the truth isn't in the testimony, but in the uncut footage? Supreme Court drops new evidence, full video on power, control and sexual crime allegations. Why now, and what does this reveal about who really holds the strings? Clues, contradictions, and consequences are all on the table. Join Red Carpet Revealed as we dig in. Let's uncover it, right now. The alert landed like a quiet thunderclap, a single-line docket update, stamped at 9:14 a.m., noting that the court had unsealed a complete audio-visual exhibit in a matter touching allegations of sexual misconduct and coercive control. Within minutes, links traveled faster than commentary, newsroom lights sharpened, legal feeds refreshed, and a grainy thumbnail, just a doorway, a shoulder, a sliver of carpet, became the day's most scrutinized image. The headline practically wrote itself. Yet before anyone pressed play, the essential question hummed beneath the spectacle: what does a full video actually change? About proof, about power, about the way we watch one another? The file's provenance reads like a chain stitched in careful knots. A device was seized under warrant after a complaint alleging coercive behavior and sexual assault. Forensic imaging followed, bit for bit. Hash values noted in a lab log with the dutiful boredom of science. Clips surfaced months later in filings and broadcasts, cropped, excerpted, debated, until counsel petitioned for the entire recording to be unsealed, arguing that fragments distort and that sunlight favors process. The court, after rounds of objections and a surgical opinion on redactions, agreed to release a continuous version with faces blurred and identifying details masked. The result is not a spectacle so much as a room we are invited to sit in while time passes. A room that will not explain itself. Open on a hallway with a quiet the law calls neutral. A voice enters the frame before the person does, measured, practiced. Its cadence etched by status. Another voice replies, softer. Not timid so much as careful. The way one walks across boards that may creak. The camera's perspective is ordinary, shoulder height. As if carried by someone who learned to let objects tell stories, a coat hung like a flag at half-mast. A stack of mails crusting the edge of a console. A single chip mug. The allegation that surrounds this footage, according to filings, is that coercion made consent a ceremony of compliance. The defense position, in public statements, is that the encounters were consensual in that context, omitted here, would absolve. The video, stubbornly anti-theatrical, gives no verdict. It gives sequence. Courts prefer sequences to shocks. They weigh continuity as a cousin of credibility. Did the lens blink when the story needed it to? Forensic notations say no hard cuts in the key interval. The audio shows gain fluctuations consistent with the phone's automatic leveling, not manual tempering. Machines do not measure intimidation, nor do decibels confess. What the recording does show, observably, proximity negotiated like a contract, touches that sometimes anticipate flinch, a hand reclaiming a wrist not to yank but to place. At minute marks noted by counsel, questions surface unadorned. Are you comfortable? A sentence that, said in two different rooms by two different people, can mean opposite things. The law tries to separate words from weather. The viewer feels the weather anyway. Coercive control is a phrase that migrated from advocacy into statutes in some places, and into expert lexicons elsewhere. It names a pattern rather than an episode: isolation, humiliation, micromanaged finances, long erosion of self. The video alone cannot prove pattern, but it offers behaviors that analysts will plug into frameworks like sockets, interruptions that redirect, choices pre-answered, apologies deployed like placards, visible, performative, ultimately unreadable without deposition or diary. In modern courtrooms, psychologists and criminologists translate these micro moments to jurors who ask the most human of questions: why not leave? Why not shout? Why not fight? The best answers, trauma, dependency, the social math of safety, are not cinematic. Neither is this footage. The release itself is its own event. Courts do not publicize to narrate, they publish to neutralize rumors and to anchor public discourse in a common artifact. Yet once released, a file lives 1,000 lives, clipped, captioned, contexted by strangers, fed through algorithms that reward emotion's sharp edges. The court's order, careful and almost apologetic, acknowledges the prejudice risk and tries to mitigate harm. Faces masked, names redacted, specific times and addresses withheld. Even then, The public's appetite for certainty will scrape at redaction boxes like fingernails at paint. The institution's gamble is that a whole picture, blurred where necessary, does less damage than a collage of strategic fragments. There is a moral weather report that accompanies any such video. And it changes by hour. By noon, advocacy groups praise transparency while begging media to avoid sensational edits. By 2, defense counsel reiterates denials and argues that the recording, stripped of the minutes before and after, is complex intimacy into prosecutorial grammar. By evening, commentators rehearse a familiar chorus: believe survivors, believe due process, believe evidence, believe that evidence can lie by telling the truth too narrowly. The only consensus: none of us are neutral watchers anymore. Technical people return us to the ground. We talk of variable frame rates, of mic bleed and room impulse responses, of the telltale glitch that reveals a splice where none should be. Their caution feels like mercy. The point of an investigation is not to feed certainty, but to vet it. Hash values mean a body of work, not just this video, can be verified against itself. Chain of custody means the passing of hands left fingerprints only where procedures permit. What technology cannot weigh is the physics of power in a room. A title change is a chair into a throne and a request into command. All this prelude matters because the legal value of a recording is tethered to how a judge will instruct those who must weigh it. Probative or prejudicial? Foundational or inflammatory? Full videos presents in the digital commons raises the risk that potential jurors will arrive already full. These exist: voir dire, sequestration, stern instructions not to watch what is already in their pockets, but the post-platform world is a sieve. Transparency satisfies today's demand while complicating tomorrow's trial. That paradox is now jurisprudence's roommate. The video also cannot show, and which the court's release cannot conjure, private histories. The months before, the text messages that sanded down a no into a maybe. Money transfers that felt like gifts until they did not. Promises that read as mentorship but burned like leverage. These live in other exhibits, other affidavits, other hearts. The footage is a spine, not a body. Everything else must be sutured to it: medical records, witness statements, experts who explain how memory frays and how it is stitched back when asked to stand in the light. To watch the full video is to feel the strange intimacy of a case file breathing beside you. One appreciates why partial clips, however viral, are mischief. They smoothed ambiguity into narrative. Full recording resists that smoothing. Its boredom is instructive. Power is often administrated in quiet. Real harm occurred, need not shout. Where a television writer might script a confession, the law is content with small anchors: who initiated contact, who set the location, closed the door. The rest, the law says patiently. We have cross-examination. By nightfall, a counter-genre rises: media literacy primers dressed as op-eds. They urge audiences to separate detail from inference. Fuse the seduction of punditry. To remember that alleged is not a cop-out but a constitutional courtesy. Some readers sneer, others exhale, grateful for a tone that does not require them to be judge and jury before dinner. A better question emerges. Quieter but more useful: what systems failed such that this video had to become the arbiter of anything? Police, then, functions on two frequencies. It is an object in a case, subject to rules and rulings. As a cultural mirror, reflecting how quickly we convert ambiguity into ammunition. If there is a mercy in the court's act, is the insistence that the long version, the version that lets silence be evidence of nothing, be part of the conversation. If there is a warning, it's that no video can carry the whole weight we keep asking it to bear. Morning headlines after the release chant their hope and hostility in equal measure. The evidentiary questions sharpen: is the file authentic in a way that a jury can trust? Is it admissible in whole or only in slices? And under what limiting instructions? How will public viewing contaminate the pool from which finders of fact must be drawn? City rides the shoulders of technicians, admissibility sleeps in the judge's pen. Between them, interpretation prowls, daring anyone to claim objectivity without qualification. The rules of evidence, those dry oaths the public meets only when a scandal summons them, become suddenly tender. Authentication is a gate. The proponent must show the exhibit is what it claims to be. That hurdle is not simply technical, it is narrative. Courted, when? Why? With what device? Whose knowledge? Relevance comes next. Does the video make any material fact more or less likely? If so, a balancing follows, probative value against unfair prejudice. Judges are asked to be mathematicians of feeling, subtracting spectacle, dividing outrage by context. Where sexual crime allegations are concerned, hearsay rules and rape shield protections complicate the calculus with humane guardrails meant to keep trials from becoming reenactments of older harm. The defense, in statements and filings, signals its angles. Context, they argue, turns accusation into ambiguity. A hand on a wrist may be guidance rather than force, a lowered voice may suggest intimacy rather than intimidation. They will say that the recording's chronology omits moments that would change interpretation, that the camera's vantage compresses depth and exaggerates closeness. Consent can be awkward without being absent. In response, prosecutors point outward, away from the pixels, toward corroboration, messages whose tone congeals into pattern, medical notes that do not dramatize but do insist, witness accounts that rhyme in the way truth often does when carried by different tongues. Due process is a slow instrument in a quick-take culture. Clash is corrosive. Viral files summon audiences. Audiences become surrogates for juries they will never join. Issue admonitions not to try cases in the press. Counsel replies that reputational harm is already trial by trend. Gag orders tiptoe along constitutional cliffs. Court can sequester a jury, it cannot sequester a nation. Into that gap leak think pieces and rage threads. Survivor narratives and defense manifestos, each staking claim to moral high ground that the law does not traffic in because it cannot. Hovering over all of it is fear of fakery. Deepfakes, those minted lies that wear faces like stolen coats, have taught even honest viewers to doubt their eyes. Forensic labs answer with new arts, photogrammetry to map light bounce, spectrograms to catch splices where waveforms should be smooth, AI that knows the signature of GAN noise the way a sommelier knows a region by smell. The court's confidence in this video rests part on such work. But experts speak in probabilities, not absolutes. A jury must believe that more likely than not, or beyond a reasonable doubt, can be built from that grammar. What does survivor-centered reporting look like in this maelstrom? It resists the gravitational pull toward prurience. It avoids names where privacy is still a right, not a forfeiture. It refuses to paraphrase pain as clickbait. Remembers to write, each time, that allegations remain just that until adjudicated, that belief and proof are separate duties held by different actors. It posts resources, hotlines, legal aid, community organizations that tend to the aftermath long after cameras leave. It keeps the word alleged not as a shield for the accused but as a shelter for the process. Step back farther and a different map comes into view, the power structures that incubate both abuse and accountability. On one axis, institutions, courts, police, legislatures, the platforms that profit from attention, employers that weaponize policy when convenient and ignore it when not. On another axis, culture, norms that train deference in some and entitlement in others, scripts that mistake dominance for charisma, that confuse mentorship with possessor myth. Video's real lesson may be less about one incident than about the supply chain of impunity and the logistics of courage. Form is to be harvested from this moment. It will grow in policy soil. Evidence release protocols can be tightened to protect privacy while serving transparency. Thresholds clarified so that public interest is not simply public curiosity. Platforms can throttle graphic virality without hiding public records. Victim notification rules can be strengthened so that no one is surprised by their own trauma in the news. Defense rights must be guarded with equal fervor, disclosure timelines enforced. Redactions not used as bludgeons. Appointed experts funded where the science outruns budgets. Liberty is a two-handed craft. Then there are the limits no reform can erase. A video cannot resolve intent with certainty. It cannot decode the archive a body keeps when it has been rehearsed over years, to endure. Not render a legal definition of consent that must be applied to facts only the participants truly recall. A court can approximate. It can draw lines the way cartographers do, beautiful, useful, wrong in detail and right enough to travel by. Verdicts arrive. They will not end the cultural litigation that outlives them. Paths ahead fork like careful rivers. Courting is fully admitted. Counsel will fight over instructions that tell jurors how to weigh what many have already watched. If admitted only in part, additional context or redactions will be argued like territories. If authenticity is contested, The case may detour into lab work in expert battlefields where the jurors' eyes glaze even as the stakes sharpen. Each path leads to appeals that will cite this moment as precedent. Note in the common law of screens. And yet, amid the diagrams and doctrines, a simpler human register persists. A video was released. People watched. Some felt seen, others felt hunted. A few decided to study instead of react. Somewhere a complainant read comments and chose, for health, not to read more. Somewhere a respondent looked for language that can hold both denial and the knowledge that denial does not erase harm perceived by another. Somewhere a judge marked time between filings and, in quiet hope, the law could still produce outcomes that feel like justice rather than like victory. Return, finally, to the opening wager, that the full video would change something essential. It did and it didn't. Changed the conversation by slowing it down. It didn't change the obligation to corroborate, to contextualize, to resist the theology of the single clip. It gave the public a mirror and asked us to consider how we look when we watch. Gave the court a heavier bench to lift and asked it to remember that transparency is a floodlight while justice remains a scalpel, bright enough to see, precise enough to spare. Weeks ahead, more filings will stitch this exhibit to others. And the story will slouch, as stories must. A forum where rules decide what words may be spoken and in what order. The rest of us will go back to our lives until the next alert turns a doorway and a sliver of carpet into referendum on who we are. If there is wisdom to salvage from this release, maybe no more ornate than this: watch with humility, argue with care, and let the process do the slow work the footage cannot. Only then will the full video be what it should be, one piece of a larger mosaic, not the wall itself. Video changed the conversation, but not the burden of proof. It slowed a runaway narrative, reminded us that context is evidence, and proved that transparency is a floodlight while justice is still a scalpel. You watched may illuminate power, control, fragile grammar of consent. Yet it remains one exhibit among many. The only path from allegation to verdict runs through due process, chain of custody, admissibility, corroboration, and the courage to let uncertainty be examined instead of exploited. If the footage matters, it is because it pushes us toward a harder discipline. Watch with humility, argue with care, and let the full record, not a single clip, carry the weight. Thank you for reading with patience and rigor. Your attention, measured not in clicks but in care, makes space for survivor-centered reporting, fair defense, and a courtroom that can still do its slow, precise work. This coverage helped clarify more than it inflamed. Because of readers like you. Stay with us for follow-ups as the filings evolve and the law, not the timeline, has the last word.